University of Western Ontario Faculty of Law in Canada, and I've been attending the IHL Dialogs for many, many years, interrupted only by the birth of 2 children and the year that it went to Nuremberg. And I'm very, very pleased to be asked to present this year in review again, to look at developments in international criminal law from August 2017 until today. I'm going to focus on 3 themes today: confusion, hope, and focus. Confusion. This is what I and many others around the world felt when the International Criminal Court Appeals Chamber judgment in the Bemba case was issued in June of this year. I should mention here that prior to becoming an academic, I was a diplomat. I worked in the world of diplomacy for the Department of Foreign Affairs in Canada. And so when I say confusion, I actually mean shock and dismay. And when the judgment came out, I didn't really know what to make of it, but it felt like a bomb had gone off in international criminal law. I'll explain why. So let me give you a little bit of background for those who are not following the Bemba case at the International Criminal Court. The case focuses on events in the capital of the Central African Republic during the Patassé presidency. After surviving 2 coup attempts in 2001, he faced a third in 2002, this time by his former chief of staff, François Bozizé. This led to a civil war in the Central African Republic, and President Patassé invited the Mouvement de Libération du Congo, or MLC, an armed group based in the Democratic Republic of the Congo, to help suppress the rebels. In 2004, President Bozizé, as he then was, referred the situation to the International Criminal Court. And in 2005, the International Criminal Court's prosecutor sought an arrest warrant against the MLC's president and commander-in-chief, Jean-Pierre Bemba Gombo, or Bemba. And Bemba was then arrested in Belgium. Out of 10 charges that Bemba faced, 7 were of gender-based crimes. Rape as a crime against humanity and a war crime, other forms of sexual violence as a crime against humanity and a war crime, torture as a crime against humanity and a war crime, the war crime of outrages upon personal dignity, all committed through acts of rape or other forms of sexual violence. And the prosecutor argued that women were raped on the pretense that they were rebel sympathizers. Men were also raped as a deliberate tactic to humiliate civilian men and demonstrate their powerlessness to protect their families. So that was one of the bases of the case against Bemba. And this was the very first case at the International Criminal Court that included charges for rape of male and female victims, both, and the first to consider the principle of command responsibility. So it was potentially a precedent-setting case. In March of 2016, Bemba was unanimously convicted by the International Criminal Court's trial chamber for command responsibility for acts of rape, murder, and pillage committed by his troops in the Central African Republic, making him the first person convicted of rape in the International Criminal Court. The conviction was based on, among other evidence of the rape by male MLC soldiers of 28 people. There were 25 female prosecution witnesses, 2 male prosecution witnesses, and female victim participants. The trial chamber concluded that the measures taken by Bemba, quote, patently fell short of all necessary and reasonable measures to prevent and repress the commission of crimes within his material ability. This judgment was detailed. It contained extensive reasoning. And the case marked a turning point for the International Criminal Court's prosecutor in the prosecution of sexual and gender-based crimes. The trial chamber sentenced Bemba to 18 years imprisonment, minus the time he'd already served in the International Criminal Court's detention center. Bemba was also convicted in October of 2016 for corruptly influencing witnesses in his own case a conviction that was upheld in March of this year by the Appeals Chamber. In June of this year, the Appeals Chamber released its judgment. It was a split judgment. 3 of the 5 judges voted to overturn Bemba's convictions, and he was released. Bemba is now running for president, representing the MLC. If this trial had been poorly run, if the judgment had been poorly reasoned, if the evidence was not strong, I would not have been confused, aka shocked and dismayed, at the judgment of 3 of the 5 appeals court judges to overturn his convictions, but that was not the case. The trial had run relatively smoothly. The evidence, particularly of sexual violence, was very strong. And there was good evidence presented by the prosecution that Bemba himself did not take the necessary steps to rein in his troops when they were committing atrocities, including sexual violence. And the trial judgment was logically reasoned. So what happened? 3 judges of the Appeals Chamber made questionable findings on a number of matters, and I will highlight 2 of these. First, the majority appeals judges changed the standard of review on appeal after the appeal had been heard and without notice to the prosecution, defense, or victims. Under international criminal law, at the International Criminal Court and other tribunals, prior to the Bemba Appeals Chamber decision, the standard of review was whether a reasonable trier of fact could have reached the finding in question, based on the evidence that was before the trial chamber. In what has been described by the dissenting judges, the prosecutor, and commentators as a significant and unexplained departure from the normal standard of review, the majority instead took select pieces of evidence and did not consider all of the evidence, and based on a review of only those pieces of evidence, looked at the trial chamber's factual findings and found some doubt, and then substituted their judgment as to the factual determinations made by the trial chamber. And the majority does not explain why a departure from the reasonableness standard was, in their view, necessary in this case. Now, the reason why a margin of deference is usually given to the trial chamber on determinations of fact is, of course, because the trial chamber has examined all of the evidence, the totality of evidence before it. And this was years of evidence that the trial chamber considered in a lengthy and complicated trial. As the prosecutor stated after the release of the appeals judgment, the majority appeals judges, quote, approach would seem to confuse the standard of proof, which the trial chamber applies having heard all of the evidence, with the standard of appellate review, which applies when the appeals chamber considers the trial judgment. As well, the dissenting judges pointed out in a much better reasoned dissent that if some doubt or serious doubt were the standards of review, it would mean that in any case where there's a trial that has a dissent, then at the appeals level there would necessarily be an overturning of any convictions because obviously the dissent would raise some doubt. In my view, the majority judge's approach in changing the standard of review on appeal was simply unwarranted. Secondly, the majority of the appeals chamber essentially lowered the standard of command responsibility for those commanders who are not in the field with their troops, basically rewarding commanders who are remote and who do not take effective actions to supervise their troops. And why do I say this? I say this because the majority judges found that the trial chamber did not pay enough attention to the difficulties that Bemba, as a, quote, remote commander, faced in investigating the conduct of his troops in another state. So they took the evidence heard at trial that he had taken certain steps, for example, to set up ineffective investigations, and concluded, quote, that measures taken by a commander cannot be faulted merely because of shortfalls in their execution. Diane Amon, who for many years participated in the International Humanitarian Law Dialogs here, is now the prosecutor's special advisor on children in armed conflict, and she pointed out, after the release of this judgment, quote, "Command responsibility doctrine recognizes war's awful consequences, and so imposes extra duties of care upon officers who accept to lead others in the use of lethal armed force. Evincing scant regard for the ethical roots of the doctrine that imposes extra duties of care upon military leaders, the Bemba appellate majority thus transformed command responsibility into an admonition with little effect, a legal burden too easily shirked." Similarly, the two dissenting judges rejected the majority's uncritical acceptance, as they said, of the defense's submission about the difficulties of conducting investigations in the Central African Republic. And unlike the majority, the dissenting judges held that, quote, "If the results of measures taken, in this case by Bemba, are unsatisfactory, and a commander does not follow up with other measures that are available in the circumstances, it cannot be said that he or she has discharged his or her duty to prevent, repress, or punish crimes committed by his or her subordinates." So, an Australian colleague of mine, Rosemary Gray, put it very well in an email to me. She said, "As a result of this decision, remote commanders with little interest in stopping their troops from committing rape may breathe a sigh of relief. When it comes to assessing all necessary and reasonable measures, the bar for preventing and responding to reports of rape by one's troops, especially if those rapes are deployed abroad, has been set remarkably low. And the result is that thousands of victims of the MLC in the Central African Republic are left without justice." On that depressing note, I will now turn to my second theme, which is hope. I have actually felt hopeful this year about the international criminal laws community's increasing understanding and recognition, more sophisticated recognition of sexual and gender-based violence committed against women, girls, men, and boys in conflicts around the world. 20 years ago, the Rome Statute was adopted, which at the time was the most gender-sensitive international criminal statute, and still is. These provisions were then replicated in the Special Court for Sierra Leone statute and elsewhere. But the challenge has been to take those words on paper and put them into actual practice. And there have been many steps forward and many steps backward in the last 20 years, many stumbles. There has been progress at the Yugoslav War Crimes Tribunal, the Rwanda War Crimes Tribunal, the Special Court for Sierra Leone, and the extraordinary chambers in the courts of Cambodia. But this progress has often been beset also by regressions. I've already outlined the significant step backward, that is the Bemba Appeals Chamber judgment. But let me focus on some steps forward. The recognition of forced marriage began with the Special Court for Sierra Leone, which convicted individuals for the first time in an international criminal tribunal of a crime which included, in that scenario, the abduction of girls and women, the assigning of them with no say on their part to become so-called husbands, in quotes, of fighters with the Revolutionary United Front and other rebels, and forcing those girls and women to submit as sex and domestic slaves. And they were referred to as bushwives. And many of these girls and women, and I should stress that many of them were girls, were subjected to extreme physical and psychological violence, and many of them also had children as a result of the ongoing rape. Binta Mansoureh mentioned yesterday that many of those who survived this experience were then subjected to stigmatization by their communities, by their families, thereby continuing their victimization. The extraordinary chambers in the courts of Cambodia have also examined forced marriage of a somewhat different nature, but informed by the judgments of the Special Court for Sierra Leone. In the Khmer Rouge, men and women were forced to marry each other, often in mass ceremonies, and expected and pressured to procreate. The second judgment in case number 2 at the Cambodia Tribunal will consider this, and it will be issued in November, so something for us to watch. And as part of the outreach done by the Cambodia Tribunal this past year, the Victim Support Section conducted a mobile exhibition on forced marriage during the Khmer Rouge regime with the aim of increasing intergenerational dialogue on forced marriage within Cambodia. There has been progress in this respect. Where it was not discussed before, where it's not even known before in Cambodia, now forced marriage is something that is discussed much more widely within the country. Also, in March of this year, the International Criminal Court issued a warrant of arrest for Al Hassan, an alleged member of the Ansar ad-Din and de facto chief of the Islamic police. He's alleged to have been involved in the work of the Islamic court in Timbuktu, Mali. He's charged with taking part in the destruction of mausoleums in Timbuktu using Islamic police forces, but he is also charged with the policy of forced marriages in which victimized females in Timbuktu and which led to their rape and sexual enslavement. And these were both women and girls. He's charged with crimes against humanity, torture, rape, and sexual slavery, the persecution on the basis of gender and on the basis of religion, and other inhumane acts. And he's also charged with war crimes, including war crimes of rape and sexual slavery. He was surrendered to the court in March of this year, and he's currently in the court's custody, and his confirmation of charges case will begin in May of next year. This is a good news story. The fact that he's in custody and that this case will expose some of the gender-based crimes that have taken place in Mali. In other hopeful developments, the International Criminal Court's Ntaganda case began closing statements today. So they're ongoing right now as we're sitting in this room. That case involves the former deputy chief of staff to an armed group in the Democratic Republic of the Congo, and it's considering, amongst the crimes, rape and sexual violence committed by Ntaganda's fighters against their own girl soldiers. This will be the first case that looks at this issue. And the International Criminal Tribunal for the former Yugoslavia's final judgments, for example, in the Mladic trial judgment last November, contained convictions for persecution as a crime against humanity carried out through rape and sexual assault. Catherine, last night, I saw her sitting here. Where are you, Catherine? Yes, right there. Last night, who presented the Catherine Fight lecture, was appointed head of the International Impartial and Independent Mechanism in 2017. The IIIM, as it's often called, collects, consolidates, preserves, and analyzes evidence of violations committed in Syria since March 2011. And in November of this past year, Michelle Jarvis, the former deputy to the prosecutor at the Yugoslav War Crimes Tribunal, a noted gender expert in international criminal law, was appointed deputy head of the IIIM. And together, Catherine and Michelle have articulated a gender-sensitive framework for collecting and analyzing information brought in at the IIIM. At the local level, in December of 2017, members of a militia group in the Democratic Republic of the Congo were convicted of raping 37 girls from Kavumu in Eastern Democratic Republic of the Congo. The girls they raped were between the ages of 12 years old and 8 months old. 10 of them were convicted of crimes against humanity. They said that they carried out the rapes in the belief that they would gain supernatural powers on the battlefield. The mastermind behind these attacks was a powerful member of parliament in the Democratic Republic of the Congo, someone who prior to this would feel that he had impunity. But he didn't. He was among those who were convicted. The trial was held in a mobile military court so that locals could attend and see justice done. It lasted over a month. And Fabrizio mentioned yesterday that these convictions were upheld on appeal last month. In other developments on the theme of hope from the past year, in April, the International Criminal Court's prosecutor sought a ruling from the court on the question of jurisdiction. That is, whether the court can exercise jurisdiction over the alleged deportation of the Rohingya people from Myanmar to Bangladesh. That was the question she asked of the court. She pointed to reports that said since August 2017, more than 670,000 Rohingya have been intentionally pushed, deported, across the international border from Myanmar into Bangladesh. She pointed to the fact that the UN High Commissioner for Human Rights described the Rohingya crisis as, quote, a textbook example of ethnic cleansing. She pointed to the fact that the UN Special Envoy for Human Rights in Myanmar said that what happened to the Rohingya potentially bears, quote, the hallmark of genocide. She also pointed out that the attacks leading to the deportations were well organized, coordinated, and systematic, and they included killings, rape, torture, enforced disappearance, and destruction and looting of hundreds of villages, as well as livestock, crops, and other personal property. Of course, these actions occurred on the territory of a state, Myanmar, which is not party to the International Criminal Court's Rome Statute. But they resulted in people fleeing into a state, Bangladesh, which is party to the Rome Statute of the International Criminal Court. And her argument is that an essential legal element of the crime, crossing an international border, occurred on the territory of Bangladesh. The court then invited amicus curiae, or friends of the court briefs, from academics and civil society. While there's no decision yet, I include this under hope because it represents one possibility of potential justice at a time when the deadlock within the United Nations Security Council otherwise stymies movement towards international justice for the Rohingya. And yesterday, a report by the UN Independent International Fact-Finding Mission on Myanmar, and I'd mentioned that it concluded that there was responsibility at the very highest levels of the Myanmar military. That fact-finding mission also concluded or called for the situation in Myanmar to be referred to the International Criminal Court or for an ad hoc International Criminal Tribunal to be created. And in the interim, it recommended the creation of an independent, impartial mechanism to collect, consolidate, preserve, and analyze evidence of violations. It also recommended that the individuals named in the report, the top military officials, have individual sanctions brought against them as they appear to be most responsible. I'll turn to my third theme, which is that of focus. I wanted to mention something that during our unexpected break, Michael Schur pointed out to me, and that is that yesterday, Bamba was barred from running for president in the Democratic Republic of Congo. I somehow didn't know that, but that is positive news in some ways. In other ways, it's probably just a political decision because he would have won. But at any rate, at least that step has taken. But we do need to keep our eye on this. Where else do we need to focus, in my view, in the coming year? Budgets. All of you except Herman will be like, oh, budgets, why are you talking about budgets? It's not the most sexy issue, but it's vitally important, as you know, in running a court. Continued support and funding of the International Criminal Court, including the Office of the Prosecutor, comes from the International Criminal Court's Assembly of States Parties. And despite the international community's continuing calls on the International Criminal Court Office of the Prosecutor to take on more and more and more situations, the budget of the International Criminal Court has only increased at a very low rate a rate less than inflation from year to year. At the 2017 annual meeting of the Assembly of States Parties, states approved a budget of 147.4 million euros for 2018. And this budget is not only for the Office of the Prosecutor, it is for the Office of the Prosecutor, the Registry, the Secretariat of the Assembly of States Parties, the premises, the Secretariat of the Trust Fund for Victims, the Independent Oversight Mechanism, the Office of Internal Audit, and payment towards the host state loan taken out to pay for the new permanent building of the International Criminal Court, and of that, it's almost 4 million euros. The court had requested 151.4 million euros, which was an increase of 4.4% over the 2017 budget, and the Committee on Budget and Finance reduced that recommendation to only a 2% increase, and then states ended up only increasing the budget by 1.47%. Very small increase in the budget. What does that mean in reality? Some people might be like, well, whatever, at least they have money. But what it means in reality is that the Office of the Prosecutor can only ever take on a handful of cases at any given time. They can only actually have proceedings of approximately 3 cases at any given time. And the number of cases, the new cases that it can take on, will be limited because of the inability to spend money on these new investigations. In other words, the Office of the Prosecutor does not have sufficient funds to meet the demands of what it's been asked to do. On the same note of funding, continued funding of other international criminal justice mechanisms is important. You heard yesterday the prosecutor of the Residual Special Court for Sierra Leone mentioning about her and others within the court's ongoing work in raising money to keep that small residual court afloat, so as to ensure monitoring of the convicted individuals who are serving sentences, continued victim protection, and responses to issues that arise. For example, Charles Taylor's public phone call to supporters in Liberia during the election campaign last year from his prison in the United Kingdom, where he indicated that he was still committed to revolution in Liberia. You need to have a court, a residual court, to continue to monitor these events and take action. And last year, the extraordinary chambers in the courts of Cambodia considered a potential stay in proceedings, almost a year ago, due to a lack of funding, which then opened the door to another way that the government of Cambodia could block cases that are unpopular with its government. But in the end, the funding crisis was averted. Similarly, it will be important to follow the budget discussions within the United Nations on the mechanism for international criminal tribunals, the residual court for the International Criminal Tribunal for the former Yugoslavia and Rwanda, to ensure that its work is not narrowed and narrowed and narrowed in this way through budget reductions. I realize not many people pay attention to funding and budgets, but lack of funding is a way to choke international criminal justice. So I urge more attention in this regard. My third area of focus. At the Special Tribunal for Lebanon 1 year ago today, in the IHLD case, the legal representatives of 72 victims participating in the proceedings began presenting evidence on the victims' behalf. This marked the first time that victims of terrorism have presented their case before an international criminal tribunal. And this evidence consisted of live testimonies, witness statements, and documents. And what they did was present evidence of the harm that they suffered as victims collectively and individually as a result of the 2005 murder of Lebanese Prime Minister Rafik Hariri and the death and injury of other persons. Final trial briefs were filed in the case over the past month, so it will be important for us to follow the outcome of this case in the coming weeks. In December, this past December, at the annual meeting of the International Criminal Court's Assembly of States Parties, states decided to activate the crime of aggression, which was an important step in international criminal law. However, the negotiation around that activation left some open questions which we will need to watch. And I'm going to promote Jennifer Trahan's paper, which she has in the lobby, which you should pick up on your way back into the lobby, where she examines these open questions that could really raise issues in the future about whether or not aggression can be prosecuted by the International Criminal Court. Finally, yesterday, Ambassador Stephen Rapp mentioned that international criminal law is facing some strong headwinds at the moment, as he put it. Threats from the Philippines to withdraw from the Rome Statute, continuing issues within South Africa on this same point, delays in the creation of already agreed criminal justice mechanisms in the Central African Republic and South Sudan, deadlock in the UN Security Council on the empowerment of the creation of international criminal justice mechanisms, and, as we heard this morning from Jennifer, 4 vetoes in the last year by Russia regarding the use of chemical weapons in Syria. And yet, we see windows being opened when doors have closed on international criminal justice, with the creation of the IIIM for Syria and discussions of something similar with respect to the Rohingya crisis. And we must keep pressing for justice, for new windows to be opened when doors are closed. So in conclusion, confusion, hope, and focus. Our challenge in the next year is to press for hope to be more common than confusion or shock or dismay. And I look forward to hearing from you about things that have happened in international criminal justice in this past year that you think fill these themes, or about areas that you're focusing on looking forward and why. Thank you.